Yeah, good afternoon and welcome to this webinar dealing with restructuring and redundancy in a COVID-19 environment. I should do some introductions. For those who don't know me, my name's Scott Wilson. I'm a partner in the Duncan Cotterill Employment and Health and Safety team. I'm based in Christchurch, and presenting this webinar with me is Julia Hurren, who's also in our Christchurch-based Employment and Health and Safety team. As I reflect back on the early days of the lockdown, many of the inquiries we were receiving early in the piece related to the wage subsidy and the leave support scheme. But even at that early stage, employers were flagging that depending on how things went and with the when the wage subsidy had been exhausted, that they were redundancies were on their radar, and certainly as the government support has run its course for many businesses, that has proved to be the case. And you just need to open up the paper or look on the Stuff and Herald websites to see that many significant businesses are in the throes of redundancies and restructuring at the moment. So this webinar is probably timely. So what are we looking at covering? So we'll go look at very briefly the key legal obligations, and restructuring and redundancy is an area that is highly nuanced and can be quite tricky. We'll look at the COVID-19 considerations, deal with the business case. That's the basis of the substantive justification if there's a challenge. It's important to get that right, and we'll deal with that shortly. Then look at the consultation requirements, and the consultation requirements are a lot wider than many people appreciate, so we'll go through those. Then focus on common mistakes that employers make, and we'll look at then move to look at employee wellbeing in a change process. It's something that should not be overlooked. And then there's a case or two that's come out of the Employment Relations Authority recently that we'll touch upon. So starting with the key legal obligations, and this is the legal framework employers have to operate within and comply with if they're to minimise the risk of a personal grievance claim. Now, the first section we've got there is section 103A. It'll be a section that you've at least heard of and possibly are familiar with. It's a key provision in the employment relations legislation. It sets out the test for justification, what employers will get measured against if there's a challenge to any decision they make, and it sets out the standard that employers will be held to. And as you probably recall, the standard is what a fair and reasonable employer could have done in all circumstances, and the test recognises that there's a continuum, that there's a range of responses that are open to a fair and reasonable employer. Section 103A also sets out the minimum procedural requirements employers have to meet, and we'll touch upon those just in a moment. Now, in a redundancy context, in a redundancy setting, the starting point, and as a general rule, employers are entitled to structure their businesses as they see fit. That's the law recognises that, the courts recognise that. The proviso to that is that any decision an employer makes in a restructuring context has to be one that is open to a fair and reasonable employer. And in the past 7 years, the courts have been more willing to lift the hood and look under the hood, if you like, and consider whether the decision that the employer made was one that a fair and reasonable employer would have made. If you look at it cynically, you could say that if the courts agree with the decision, they might accept it as one that's open to a fair and reasonable employer. If they don't, then it's not. Prior to and this new test was introduced in a case, a farming case, Totra Hills and Davidson, in 2013. Prior to that, it was enough for an employer to show that their decision was a genuine decision. So if the decision was genuine but a poor decision, the courts wouldn't interfere with it. Things have changed. Things have moved on in the last 7 years. In terms of process, in terms of good faith, even where an employer has good commercial reasons, good business reasons for restructuring the business, they still are required to go about things in a fair manner. There needs to be a consultation process. The employer also has to comply with the duty of good faith, the statutory duty of good faith. Now, that statutory duty is a fundamental plank of the employment relations legislation. Complying with the duty includes providing those potentially affected with all relevant information, providing them with an opportunity to comment on that information, provide feedback in respect of the proposal in a restructuring context, and not misleading or deceiving them. The other factor that, or material consideration in a restructuring context at the get-go is, and should not be overlooked, and it is sometimes overlooked by employers, is the employment agreement and the internal policy documentation. That may set out a contractual process that needs to be followed in a redundancy setting. And if there is a contractual process, the reality is it needs to be followed. The courts view the position they take in respect of that is that a fair and reasonable employer would follow any agreed process. So an employer that might follow a process that could, in most circumstances, otherwise be seen as being a proper process, a fair process, may find themselves falling foul of the law if they don't follow the agreed contractual process. The contract, the policy documents might also outline other enhanced entitlements that may be applicable in a restructuring in a context if you get to the termination stage. So we're talking about COVID-19, so let's look at some COVID-19 considerations. Now, in an endeavour to stimulate the economy and to minimise job losses, the government provided businesses with access to a wage subsidy. That's well known, and I'm not going to go through that in any real detail. The initial subsidy was for a 12-week period, and those who applied, well, after the 27th of March anyway, were required to provide a declaration that they would retain staff for for the duration of the subsidy period. Now, for most businesses, that 12-week period has passed, and moving into a restructuring or redundancy process would not be contrary to the declaration, unless your business has provided for applied for an extension. Now, I am aware of some businesses who were in receipt of a wage subsidy that did move to restructure their business and did implement redundancies. The issues that flow from that, well, the main issues anyway, are twofold. Firstly, there's an obligation to repay the wage subsidy, and the second one, and probably more fitting and given than what we're dealing with now, is it may impact upon the substantive decision. So an employer who has moved to implement redundancies may have difficulty in justifying a dismissal from a substantive point of view if there's a challenge. The courts will look at any decision carefully and have regard to all factors in and around the employer's decision. And if they are in receipt of the subsidy, there's going to have to be good reasons as to why there was a need to move to implement the redundancies during the subsidy period, particularly when at the outset of the period the business has provided a declaration, albeit to MSD, that they would retain jobs for the period. There would have to be good reason for that. It would have to be unforeseen circumstances. All is not lost, but it's going to be difficult. That's the reality. And there's significant risks on those who did move in those circumstances. As I said at the get-go, we're Christchurch based, and what we are seeing in the current climate, which is a little bit different, and there were parallels during the lockdown to the situation that we experienced soon after the earthquake. What seems to be different here and now is that employees seem to be more willing to challenge the decision than they were post-earthquake, possibly because the options that were available to them after the earthquake in terms of going overseas or going to another region are no longer there. Now, the proposal, the change proposal. So this underlines the whole rationale for moving to restructure the business, and it's important to get it right from the get-go. It probably goes without saying, and I am going to say it, so maybe it doesn't. It's important for businesses to give careful consideration to the rationale for the change proposal. That's probably a given. Where many businesses fall foul of the law is in articulating or properly articulating the reasons for the proposal. Now, that should be done in writing, in consultation, in the consultation documentation, which is provided to those individuals, those employees who are potentially affected by the change proposal itself. Careful thought needs to go into what's the issue or what's the problem, as we've got up there, that the business is seeking to address. Why is it an issue? Generic statements without further explanation are no longer acceptable to the courts. The old school approach of using generic managements no longer passes muster. If it's about business efficiencies, the business efficiencies need to be spelt out, and that's a common phrase you see in change proposals. What business efficiency means to one business may be quite different to another. So it really does need to be articulated. What are the business efficiencies that you're seeking to achieve, or what is the rationale? Because this process is about providing employees with an opportunity to provide meaningful feedback. Evidence, we've referenced that in the PowerPoint. I referred to all relevant information before, and that's what needs to be provided. That's a key component of the duty of good faith. And what is relevant will be very dependent on the business case itself and the reasons for the change proposal. If the change proposal is about cost savings, well, what cost savings is the business, are you seeking to achieve, and how? You'll also need to provide, if that's the basis for the decision, those potentially affected with financial information to support the proposal. And it's not, and we see this quite often, enough to say that the employee has access to the financial information. It's not about the employee, so the courts say, having to second guess what is in the mind of the employer and what information amongst a whole myriad of financial information is important to them and is influencing their decision. It's for the employer, the courts say, to spell that out. In terms of the documentation, and as a minimum, we would expect to see in the change proposal documentation itself, the rationale. So this is the written document that goes to the employees at the get-go. The rationale, if it's a restructuring that impacts upon a number of employees or some employees, setting out the current structure and the proposed structure is helpful, so that the employees are able to see what is being proposed and visualise that, outlining the impact of the proposal, consultation timeframes, and there needs to be some fluidity and flexibility in and around those. The support optics, that's something Julia will deal with shortly, and also the right to representation. And some of those, such as the right to representation, is more about protecting your position, so that you're covering off your legal bases, and it's there in writing, and there's no argument later in the piece that I was never told that I had a right to have support or representation. Yes, you were. It's in the documentation itself. So it's about protecting the business. In terms of my notes here. COVID specific business reasons. Well, we've set out some common reasons there. It's that we've come across in the last 6 or so months, or however long, probably not quite that long. So the significant downturn in revenue and sales, loss of customer suppliers, shift in market requirements, those are generic terms. It's not intended to be a comprehensive list or an exhaustive list. And those particular reasons would need to be elaborated on in the proposal documentation, as I have just mentioned. Now, we've got in the second column on the PowerPoint to show you have considered the alternatives. Now, before moving to implement redundancies, it's prudent, and in fact it's necessary, I'd say, for the employer to have considered options and to have shown, and it's prudent to do this in the change documentation itself, or the proposal documentation itself, that you've done so, and explain why those alternatives are not realistic or not the preferred options. So the consultation process itself. I've touched upon it already. Consultation is about providing those potentially affected with the opportunity to comment, provide feedback, if you will, on the change proposal before any final decision is made. It's providing employees with the opportunity to influence their own destiny. The feedback, the consultation process is not a negotiation process. It's not about securing agreement. It's merely about providing employees with reasonable opportunity, with an opportunity to provide some input into their destiny, if you like. The process can be fluid, as can the timeframes. There needs to be an at-risk meeting, and that's a meeting at which employees have the opportunity to provide their feedback, ask questions, and influence to the extent they can, the decision maker. Prior to that meeting, we would suggest that there's what we would an initial meeting or a heads-up meeting in a small scale redundancy process. It might be a case of just sitting down with an individual, and it's not really part of the process. It's initiating the process, providing the individuals with a copy of the proposal documentation, telling them that you're wanting to meet with them, scheduling a meeting, giving them an opportunity before the at-risk or feedback meeting to come back with any queries, so that the feedback meeting can go ahead and is able to be as efficient as it possibly can be. In a large-scale restructuring, there might be a State of the Nation meeting, and all we're covering all those in an area or in a workplace that are potentially affected. And again, the purpose of the meeting is just a heads up. It's not about seeking feedback at that early stage. It's just about telling them what's planned so that they don't get it doesn't come from, it's not something that comes out of the blue. The feedback meeting, I've touched upon that. And I've said that the process may need to be fluid. Coming out of that meeting, there may be questions that you're not able to answer. You may need to give the employee further time to reflect on and provide further feedback. It's a process that the timeframes need to be reasonable, and it needs to be a genuine process if you're going to pass muster. And once the employer's had the opportunity of providing feedback, then it's a case of considering that feedback and making a decision. And it's a decision on the substantive proposal itself, and it's not in and around the employee's employment at that stage. In other words, whether the employee will be terminated or not. That's something that comes further down the track. There's still a few steps that need to be implemented before you get there. So where there are contestable roles, or there's a reduction in the roles that may be available, selection will need to be undertaken, and there'll need to be a selection process. And selection is an area that many employers get wrong, and it's a highly nuanced area, or it can be. It can be quite tricky, and it's an area that if you're facing it, I'd encourage you to take advice. There's a need to consult at the get-go in and around the proposed selection criteria, and that the criteria itself needs to be as objectively measurable as possible. So there's an obligation to consult with employees in respect to their proposed criteria, and I say that on the assumption that there is no selection criteria outlined in the employment agreement, because some collective agreements do actually contain contractual selection criteria. Thereafter, once you've consulted, it's making a decision on the criteria itself and applying that criteria to arrive at provisional or preliminary scores. Thereafter, and this is the area that employers often get wrong, there's an obligation to actually consult with employees in respect of those provisional scores and give them an opportunity to provide feedback on the scores that have been provided on a provisional basis. Once they've had that opportunity, it's a case of giving consideration to their feedback, adjusting their scores if that's appropriate or not, and making a decision who will be successful in respect of those roles that are going or otherwise. Thereafter, there is one final step in the process, and that is in and around redeployment, and it's an area that is often overlooked. There's an obligation to consult in respect of redeployment, even where you as the employer cannot identify any redeployment opportunities. The employee is still entitled to an opportunity to put forward any redeployment opportunities they may see as being available. And again, it's not a negotiation process. It's just about providing the employee with that opportunity to provide feedback, to provide input into redeployment. If they don't make any, provide any feedback, it's easy. It's a case of probably moving to the next step, which is termination. And likewise, if they do provide feedback, then you have to have regard to that. If there are roles that are going and the employee or employees have the skills and attributes with and could do the role with some training, then the employer is obliged to actually offer the role to that employee or those employees. The old school approach that used to be acceptable up to about 7 years ago, 7 or 8 years ago, of encouraging them to apply and throw their hat in the ring is no longer acceptable. And in terms of redeployment opportunities, even where there might be a lower level role or a junior role, it's for the employee to make the decision as to whether they're interested or not in that role. It's not for the employer to make that decision without any input from the employee. So if there are no redeployment opportunities, then it's a case of moving to termination and providing notice of termination, and just how how you can deal with that, or how you should deal with that, is something that Julia will deal with in a few slides. So that's me for the moment, and I'll pass you over to Julia.
Thank you, Scott. For those of you who don't know me, my name is Julia Hurren. I'm a Senior Associate in the Employment team here in Christchurch. Now, as Scott said at the start, please do ask questions. We have, there's a question box where you can type your questions in, and we've got some time at the end where we will go through those questions. So now that Scott has taken us through the restructuring process, I'm going to talk about what can go wrong. And it's fair to say that in a change process, or where there's potential termination of employment, it is a potential area of legal risk. As Scott has explained, it can be a very complex and complicated process, and the Employment Relations Authority is prepared to closely scrutinise an employer's actions. So we do recommend that you do take legal advice before you embark on a restructuring or change process. So up on the slide there, we've got the two key areas of risk. The first is the one we mostly deal with, and that is legal risk. You're probably familiar with the concept of a personal grievance. So if the employees are going to challenge any decision or termination of employment or any of your actions during a restructuring process, they would usually raise a personal grievance. And the most common ones we see are unjustified dismissal and unjustified disadvantage. Now, it's important to remember a disadvantage claim can be raised even if employment doesn't end and there's an ongoing relationship. And an employee may claim that some action or decision during the restructuring process was unfair and it has disadvantaged them in their employment. We also often see claims for a breach of good faith. There are obviously statutory obligations of good faith, and that includes providing employees with all relevant information and openly communicating with employees and being open and honest and constructive at all times. And we often see that employees raise concerns that there have been breaches of these obligations during a restructuring process. The final point I've got there is legal costs. because usually if an employee is raising a claim against you, they'll also be seeking to recover some of their legal costs. On the other side, we've got the heading business impacts, and these are more difficult risks to quantify, but they are still very real to the business. The first one we've got there is time. Now, a restructuring process in itself is time consuming, but I can tell you that dealing with a dispute as well is also very time consuming for the managers and those involved in that process. There can also be reputational risk, and there can obviously be external risk. For example, these things are going into the press, and we're seeing lots of reports of restructurings and Employment Relations Authority decisions in the press. There can also be internal reputational risk. If people are seen to be treated unfairly, your other employees will be seeing that happening as well. And the final point up there again is legal costs, because these can be expensive to deal with. Obviously, we think it's money well spent, but even if you are successful in defending the claims, you're unlikely to be able to recover all the costs you incur. So where do mistakes happen? As you can see on the slide, they can happen really at any stage of the process. So in terms of the business case, it's really important that you put the time and effort into getting this right at the outset. As Scott said, the historical position was that employers were entitled to run their business as they see fit, and the authority didn't generally look at that. That all changed about 7 years ago, and now the courts and the Employment Relations Authority are prepared to look under the hood and closely scrutinise your business reasons. So it's really important that you put the time and effort into preparing that business case and looking at it from an objective viewpoint to see, how would someone objectively look at this? Is it logical? Is it justifiable? The next point up there is around providing information. It is part of the good faith obligations that you are required to provide access to all relevant information in a restructuring situation. If you don't provide that information at the outset, it's quite likely that your employees or their representatives will request that information, and that can really slow the process down. If the information is not provided, then that can also be grounds for an unfair process, because employees haven't been able to fully comment and understand on the proposal. The next point up there is around legal representation. As Scott said, employees are entitled to be legally represented throughout this process, and it's important that you document this and advise employees of this. Quite often employers say that you're entitled to bring a support person. That's not enough. It does need to be a legal representative, or they need to be advised that they're entitled to have a legal representative. Timeframes can be a tricky issue. These are complicated processes and they do take time. A lot of work goes in before you start the consultation process, but it is really important that once you get going that you do allow enough time for all the steps to meaningfully occur. There can obviously be a balance needs to occur, and often there's an urgency to get things done, and employees on the other hand, they also want certainty, they want answers, they want to know what's happening. But it is important that they're not rushed, especially at the end, and that you do give employees enough time to meaningfully understand the proposal, meaningfully provide their feedback, and for you as the employer to meaningfully consider the feedback you've received before making any decisions. The next point we've got up there is around selection. As Scott said, this is a tricky area. Often employees, they can understand the proposal, they can understand the process. Where they have difficulty is understanding why it's them and not the person sitting next to them. So it's really important that you put the time and effort into really carrying out meaningful consultation with employees around selection and giving them an opportunity to comment before you make any final decisions. Redeployment is also another tricky area. There are strict legal obligations in terms of what you need to do to redeploy employees, and it's important that you do go through these steps. Even if there are no redeployment opportunities, it's important to discuss this with employees and document it as well, saying you have considered redeployment. Unfortunately, the size of the business or the state we're in, there are no redeployment opportunities available. And the final point we've got there is predetermination. So this is probably the most common issue we see, and that's where employees say that, well, the whole process was a sham, decisions had already been made, my feedback was meaningless because you already had decided what was going to happen. So legally, you do need to consult with employees when you have a proposal. And a proposal, by its very nature, is something that can be changed. You're entitled to have a working plan in mind, but you do need to enter the process with an open mind and be open to and receptive to feedback. So it's really important that you're conscious about the language that you use in your communications with employees. And that's both in the written communications and oral communications. So it's important that you use words such as proposal and if the proposal proceeds, to avoid the claim of predetermination. So that brings us to an end around the strict legal process. But before we move on, I did want to discuss employee wellbeing and touch on some of the softer considerations that it is important to turn your mind to and can make the process run a lot more smoothly. So firstly, I think it's really important, especially in today's economic climate, to appreciate that when you're communicating with employees and undertaking a restructuring process, it's inherently stressful, and obviously change is stressful in itself, and the thought of losing your job is incredibly stressful. So it's important to recognise that that's the place your employees are coming from, and just have that at the front of your mind in all your communications and interactions with employees around these issues. We always recommend providing employees with access to EAP support. A flyer on the wall in the lunchroom is not enough. In this type of process, we recommend, spelling it out to employees that they're entitled to access EAP, document it in your written communications, and give them the phone number, how they can actually contact EAP, and so they have access to that network if they need it. Time off work can be a tricky issue. There's no right or wrong answer. Some employers, they like to give employees paid special leave during a restructuring process so they can, focus on taking advice, understanding the proposal and preparing their feedback. Some employees like to work through. If an employee does ask for time off work, I would recommend giving them some paid special leave so that they can go and take the advice they need and prepare their feedback. As I said, there's no right or wrong answer, but it is something to turn your mind to, and employers can be criticised if they're working to tight time frames. They're expecting employees to work, their normal job during the day and spend all their evenings preparing their feedback and trying to understand what's happening. Company announcements, it's important that these are carefully drafted and prepared. They are going to be scrutinised by the employees involved and their representatives. And it's important to think about who's the appropriate person in your organisation to communicate these messages. Notice, again, there's no necessarily right or wrong answer. You can require employees to work out their notice period in a restructuring if you end up terminating employment. This can be difficult for employees if they've gone through a selection process, they're told that they're not needed and they're the lower candidate, to then have to work in another month. What we recommend is that you turn your mind to this, you assess what you need from the employee in terms of handover, and you have a good faith discussion with employees around what's going to work. Outplacement support is common. There's no legal obligation to provide outplacement support, but this may be something that's covered in policies. So it's always important to check what your policy documents say. But it is something that is becoming more common, and employers are providing employees with access to one-on-one sessions or group sessions to help them become job ready as they move on. The final point up there is farewells. And I think it's important to remember that in a restructuring, it's a no-fault termination. Employees are leaving not by choice. but some of them may have long service and work is a big part of your life. And just turn your mind to what's an appropriate farewell and goodbye for people in your organisation. So that's the end of the restructuring presentation. If you do have any questions, please send them through. Before we get to our questions though, we did want to talk about a couple of recent cases that have come from the Employment Relations Authority, where the Employment Relations Authority has addressed some of the issues we were trying to grapple with during the lockdown period. So the first case there is Gate Gourmet New Zealand Limited. This is a case about the minimum wage. So Gate Gourmet New Zealand, they operate in Auckland, and it's a business that provides in-flight catering services for domestic and international flights out of Auckland Airport. And the employees involved in this case were on the minimum wage. So during the lockdown, they were classified as an essential service, but as you can appreciate, they had a significant downturn in work, and there was not the same work available for them during the lockdown, even though they were an essential service. So what Gate did is they notified their employees that there was going to be a partial close down, and they agreed with the union that during the close down, employees would be paid 80% of their salary or wages, and they could also choose to use their leave entitlements to top that up to 100%. I should also say that Gate did apply for and they got the wage subsidy. Now this was challenged to the Employment Relations Authority, and as these employees were on the minimum wage, when they were not working and being paid 80% of their wages, they were only getting 80% of the minimum wage, so they weren't getting the minimum wage level. So the issue the authority had to consider was whether the employer did have to pay the minimum wage to those employees who were not working during the lockdown, or could they agree to pay them 80%. At the hearing, the employer argued that because these employees were not working, there was no minimum wage issue and there was no obligation to pay them at all, so they could agree to pay them 80%. There is some dispute between the extent of the agreement to reduce them down to 80%, but the authority thought that was not relevant for the purpose of this decision. So the authority considered the issue and it did not agree with the employer, and it found that the employer was required to pay the minimum wage to those employees who were not working during the lockdown. The authority said that the nature of the payment, it came from their employment agreement. They were an essential service, and the reason the employees were not working was because the employer had directed them to stay at home due to the reduced workload, and that in this scenario they were required to pay them the minimum wage. So the takeaway from here is that if you do have employees on the minimum wage, you do need to pay them the minimum wage, and if this is an issue that you may face, then we'd certainly recommend that you take advice around that. The second case is Dove Hospice, and this is a case also about payments during lockdown. So Dove Hospice operates hospice shops in Auckland, and the employees involved in this case, they worked in the hospice shops. So during the lockdown, these shops were closed and the employees did not have to carry out any work at all. Their employer, Dove Hospice, applied for and they received the wage subsidy, and Dove Hospice told their employees that they were going to pay them 80% of their salary and wages during the lockdown while they were closed, and they'd stay at home, receive 80%. There were no minimum wage issues here. During the lockdown, they also carried out a restructuring process and terminated their employment, and the employees challenged this decision. So there are two parts to the challenge. The first was that around the restructuring, and the second was around payment. The authority dealt with the payment issue as an urgent matter, so that's what this decision is about, and we're still waiting for the decision around the restructuring itself. So at the hearing, the employer claimed because there was a lockdown, the employees were not ready, willing and available to work, and so they didn't need to pay them their full salary. There was no unlawful deduction, and they could pay them 80%. It's important to note here that there was no agreement around the 80%. The employer just advised employees that they were going to be paying 80% during the lockdown. The authority rejected this argument, and they found that there was no agreement to pay the employees any less than what their employment agreements provided, and so they should have been paid their full salary and wages during the lockdown. So this is a reasonably complicated issue around the issue of ready, willing and available to work, and I'm not going to go into that in detail here, but the key takeaway from this decision is that despite the lockdown, normal employment obligations continue to apply. So if there are going to be any changes to existing terms and conditions, you do need to engage with employees and reach agreement before implementing any changes. So we're going to take some questions now. Okay, so the first question, Scott, is one for you. And that is at the very outset of the process, when you were talking about the heads-up meeting, do employees need to be represented or told that they're entitled to be represented at that very first meeting?
Look, I don't see it as being part of the process proper anyway, and so it's more about giving the employee advance warning that you're going down a consultation, or you're initiating a consultation process, and that providing them with documentation to take away and an opportunity to take advice. So at that initial meeting, I don't believe that there's any obligation to allow the employee to have representation. It's something that you do, it's an issue that you sometimes have to grapple with from time to time, but it's really just, as we have said and as we've had defined it, it's a heads up meeting, nothing more, nothing less.
Okay, thanks, Scott. So the next question is thoughts on selection inclusion of non-objective measures like demonstrating company values. So in a selection process, we recommend that, and the Employment Relations Authority in court requires that the selection criteria are as objective as possible. And I recommend that employers, they look at what skills and attributes and what qualifications are needed for the ongoing job moving forward, and that those criteria are the main criteria. The more objective the criteria, the more likely you are to be open to criticism. You can include things such as demonstrating company values, but I would suggest that they have a lower rating than the objective criteria.
Right, so we've got a question. Does advising an employee of their right to seek legal advice cover the requirement to advise of legal representation? Well, I'll deal with that. The obligation is actually to in and around independent representation as opposed to legal representation, but advising them of their right to legal representation, I believe, would satisfy the requirements of the Act.
Okay, so the next question is, when involved in the redundancy selection process, are you required to share personal scores with all employees? And would this be a breach of privacy?
You definitely have to have regard to privacy considerations when dealing with the selection criteria and scores. It's better to anonymise the scores but there is an obligation to provide those scores to others, but in an anonymised format.
So the next question is around the hospice case and how did the ERA decide against the employer? Well, as I said, the ready, willing and available question is complicated. The employer argued that the employees were not ready, willing and available to work due to the lockdown. The authority found that, but for the lockdown, they were ready, willing and able, and they should have been paid. Don't necessarily agree with that reasoning, but I think one of the clear takeaway and the clear message is that regardless of the lockdown and people's ability to attend work or not attend work, your legal and contractual obligations to employees continue to apply.
Yeah, I agree with that, and some of the reasoning in and around the ultimate decision was a bit light, to be fair. The outcome seems pretty harsh in my view. Got a question here. Is a business obliged to apply for the wage subsidy if eligible for this, or were they? Will not applying for the wage subsidy be a factor that the courts would have regard to in a redundancy setting? Look, I'll deal with that. Ultimately, I believe it's a commercial decision for the business as to whether to apply for a wage subsidy or not. Ultimately, there may be good reasons why a business didn't apply for the wage subsidy. It may be that it would have made no difference to the final outcome. It may have been a situation, if it was to do so, was merely delaying the inevitable, and it could be that the particular circumstances of the business were such that it wasn't able to pay employees at the rate required by the subsidy eligibility criteria, and they may not have been willing to take a cut, as was the case with the first case that Julia mentioned.
Okay, well, thanks very much for joining us today. Just on the next slide is a wee note from our insurer. We'd just appreciate it if you could read that. And these are our contact details. If you do have any questions or you want to talk with Scott or I offline, please don't hesitate to give us a call or drop us an email. We'd be happy to chat further. We're sorry we couldn't hold this in person today due to the level 2 restrictions, but thank you very much for joining the webinar.
Yeah, thanks for attending.